Welcome to Navigating the Landscape of Non-Compete Law in Healthcare, sponsored by Sheehan Finney. Today we have Jason Gregoire, who is the Healthcare Practice Group Chair at Sheehan Finney. He advises practitioners on all types of transactional compliance, privacy, corporate contracting, licensing, risk management, and other issues. And with him is David McGrath, Associate General Counsel and also past President and Managing Director of Sheehan Finney. He represents firms, clients in states, in federal courts, arbitration, and administrative proceedings. I'm going to turn it over to you, Jason.
Thanks, Mike. Pleasure to be here. We really appreciate the opportunity to partner with the Business Review in setting up this topic and deciding what we wanted to spend some time with you all on today. As practice group chair of the healthcare group at Sheehan Finney, we work with both individual practitioners. We work with individual practitioners, professional practices like dental practices, physician practices, veterinary practices, and then also healthcare facilities like hospitals and long-term care, home care, federally qualified health centers. And I really sat down and thought, what are some issues that, what do I get called about the most? And honestly, non-compete's one of the hottest topics and continues to be one of the hottest topics because people just really don't understand the landscape. And in fact, I'm coming at you all live from the New Hampshire Dental Society meeting up in Meredith, New Hampshire. And about 10 minutes before joining this meeting, I had a discussion with a doctor who's has a non-compete in her employment agreement and wants to start up her own practice. And we talked a little bit about, the landscape and the constraints. So I think this topic hopefully will be useful and the presentation will be helpful to you all. So we'll jump right in. I have control over the slides here. Sheila, if you could advance the slide, I'm not able to move it. There we go. All right, so what's on the agenda today? So we're first going to talk about the different types of restrictive covenants. So when folks usually call and they say non-compete, there's a lot more in terms of restrictions. We call them restrictive covenants. So we're going to talk about, what are they? And then we'll dive into both the national landscape, sort of what's going on at a federal level, and then really break things down on a state-by-state basis. We're doing this for the New Hampshire Business Review, so most of our time will be spent analyzing New Hampshire law, but we'll also cover Massachusetts, Maine, and Vermont, because a lot of our clients have operations straddling those states, or we represent individuals who are looking to potentially do business in those states. At that point, I'll turn it over to Dave to talk a little bit more from the litigator's perspective in terms of the enforcement process. So you have these restrictive covenants, you want to protect your business. What does it actually look like if you want to use these to stop somebody from doing something? And we'll also cover some tips for protecting your business prospectively. And we'll leave plenty of time for questions. All right, so what are restrictive covenants, if you've ever heard that term before? So the most common one that folks reach out to us about is non-competes. The topic of the webinar includes the term non-compete. Non-compete, as you'll see on a definitional level, differs in, it's really controlled on a state-by-state basis and can differ based on legal definitions. But for our purposes, as we're talking today, from basic terms, we're going to say a non-compete is a contractual clause that prevents a person from working anywhere within a defined geographic radius for a set time period. So a common non-compete that we see in, say, the dental industry is, you employee, once you stop working for my dental practice, cannot, for 1 year, once you leave, cannot practice within a 10-mile radius. We're going to get down into the weeds on the different variations of non-competes, but for our purposes now, kind of just wanted to set it from a definitional level. There's also what are called non-solicitation provisions. So to solicit someone in its simplest terms is to try to get them to do something, right? So on the non-solicitation of employees provision, that's you can't try to get our employees to leave here and go elsewhere, or you can't try to get our employees to change their employment relationship with the practice. Non-solicitation of patients is what it sounds like. You can't try to convince or use active or direct or indirect efforts to try to get our patients to leave the practice and see somebody else elsewhere or alter their existing treatment relationship with us. Referral sources, especially in some of the specialty practices like oral surgeons, orthodontists, they rely heavily. Most of their business comes from referral sources. For instance, the oral surgeon, they'll have, a number of general dentists that only refer to that oral surgeon. So the non-solicitation of referral sources is, again, what it sounds like. When you leave here, you can't try to poach my referral sources to send work to you at your new practice or your new business.
Hey, Jay.
Yes, Dave.
I just wanted to make a point. Sometimes what comes up is whether it matters who initiates contact. And people think of solicitation as requiring some demonstration of an initiation of contact, but it really doesn't matter who initiates the contact. As Jay was saying, if there's encouragement and there are active attempts to get employees or patients or referral sources to kind of shift over to another practice, that's typically going to be violative of a non-solicitation. Sometimes you'll see these restrictive covenants labeled differently. Instead of a non-solicit, it might be labeled a non-interference, but it's getting at the same thing, and we'll be talking a little bit more about that.
Yeah, Dave, and relatedly, sometimes we'll see, in addition to a non-solicitation of employees, another covenant that we see is a no hire of employees. So even if you don't solicit them, even if you do nothing and you follow your contract and you don't solicit, if they find you through an Indeed ad or any other way, you can't hire them, right? So that's coupled with the non-solicitation of employees provisions. Non-disclosure, right. Most of you have probably heard of, an NDA, non-disclosure agreement. Non-disclosure is the thou shall not, use or disclose our business's confidential information, right? You can't do that without our consent. That comes up in the trade secret context. It comes up in the healthcare space with HIPAA and protected health information. But non-disclosures are pretty much in every, physician contract, dental associate contract, veterinary associate contract that I've ever prepared or reviewed. And then non-disparagement, it prohibits a person from making a negative or derogatory statement about somebody. When you leave here, you can't trash us, right? We're all going to agree that you shouldn't be out there doing that, because that could really impact my goodwill as a business owner. So those are some of the common types of restrictive covenants. When I first started out, I kind of just assumed that these covenants would only appear in employment contracts, but I've seen them and Dave has seen them pop up, and we've on behalf of clients, inserted them into lots of different types of agreements. So employment agreements, kind of obvious, but there's also independent contractor agreements. If you're an owner of the business, often in your partnership agreement, with shareholder, operating agreement, buy, sell, there's often restrictive covenants that deal with if you leave here as an owner, you cannot compete. That's different than as a garden variety employee, you shall not compete when you leave. We also see these in deferred compensation agreements. So, hey, when you leave, we'll pay you $100,000 over a year. But if you compete, you forfeit that deferred compensation, right? So that's not necessarily in an employment contract, but it's related to the employment relationship. Similarly, separation and severance agreements, non-disclosure agreements for confidential information, almost always in the context of a sale or purchase of a business. APA's asset purchase agreement, SPA's stock purchase agreement, MIPA's membership interest purchase agreement, any type of purchase and sale for a business, there's almost always restrictive covenants in those types of agreements. The idea there is you're paying, you as the buyer are paying a significant amount of money to the seller, and a lot of it usually in healthcare is characterized as payment for goodwill. you don't want the seller to kill that goodwill by opening shop up next door or down the road. And then occasionally in franchise agreements and licensing agreements. So as lawyers, when we often get the call like, hey, could you look at this for me? And they just send me the employment agreement. It's like, are you sure that's the only document you signed? And as Dave, Dave does a lot of work on the employer side, representing, all types of employers, including healthcare employers. Often like non-solicitation and non-disclosure covenants will be in employee handbooks, right? So even if you don't sign an employment agreement, you always want to try to, if you can, get a copy of the handbook to see if there's anything that you agreed to. Most employees are asked to sign an acknowledgement and acceptance of the terms of the employment handbook. Sometimes it's hard to argue that those are enforceable, but you just want to know what the landscape is.
Agreed. As Jay said, sometimes there are disclaimers in handbooks that say this, that nothing in this can create any contractual obligation. But it's still important for us to know, whatever potential documents or agreements exist.
Absolutely. It's not uncommon for us to give advice to somebody and we're just looking at one document and then you get the demand letter, the cease and desist from the prior employer saying, by the way, they also signed these 5 agreements which contain restrictive covenants. So it's that's a difficult conversation when we run into those things.
And sometimes folks don't remember. They just don't remember which agreements
Absolutely.
or how many they signed, right?
Yeah, there's a lot of paperwork at intake, or in connection with that bonus, they put something in front of me and I don't really remember what it says and I can't find a copy of it. All right, so that's some basic information about, non-competes and where they're found and different restrictive covenants. We'll get into the granular detail here momentarily, but just wanted to talk a little bit about the national landscape for non-competes because I get calls and Dave gets calls about this all the time. And I think there's so much clickbait these days. There's so much coming at us that it's hard to really drill down on the state of things and follow all the developments. So I often get the call that says, non-competes are banned federally, so it doesn't matter anymore, right? I can go work up the street and that thing's not worth the paper it's written on. And that's definitely not the case. But the reason for the confusion is that in April of 2024, the Federal Trade Commission passed a regulation that would have attempted to ban non-competes in employment relationships nationwide. And it would have applied not only prospectively to new non-competes, but it also would have rescinded existing non-competes. So everybody went nuts on this. I had so many calls from clients being like, what do we do? How do we protect ourselves? I mean, this rule was not just proposed, it actually passed. And there was, a year plus of articles. I mean, Dave, how many articles, did we see about the FTC ban and you need to prepare and you need to talk to your lawyer? Ultimately, the rule was struck down by a federal district court in Texas, and the FTC chose not to appeal the decision. And so that effectively killed the rule. So there is just to be crystal clear, there is no federal non-compete ban that's in effect now. There's none pending. That FTC rule is dead. So that's why it's even more important that we understand the state by state breakdown. And as you'll see, even within a state, it often just depends on what type of healthcare practitioner and license type you have as to whether the restrictive covenant is enforceable or not.
And I'll just point out, Jay, that the devil is in the detail on these things. And even under the FTC rule, the proposed ban would have applied to non-compete agreements that prohibited competition, not from those that merely impeded competition. Big difference. And we'll be talking about that a little bit in the next slide, I think.
Yeah. All right. So we're here for the New Hampshire Business Review. So let's talk New Hampshire. That's where we practice. That's where we live. So in general, most states, and this piece isn't New Hampshire specific, most states, the courts have held that listen, we don't favor restrictive covenants. We want to disfavor imposing restrictions on people's ability to make a living, to work where they want to work. So in general, I think it's fair to say that courts, really scrutinize the reasonableness of these restrictive covenants very carefully. And New Hampshire, for a long time, courts have used this three-part test to assess the reasonableness and enforceability of a restrictive covenant. Mainly non-competes here we're talking about. So the first is the restriction greater than necessary to protect the employer's legitimate interests? So courts usually start with defining, what is the legitimate interest that the employer is trying to protect? In healthcare, a lot of the time it's goodwill, right? Dr. Jason has owned this dental practice for 30 years. He's had multiple generations of patients come through, and people come here for me, right? Not my corporation, but for me, because I know their kids and I know their grandkids, and I gave them free treatment, and it's that goodwill is something that's built up. And so folks, understandably feel very strongly that I should be able to protect that goodwill. Another legitimate interest that courts have found is protection of trade secrets and confidential information, right? Think the secret sauce, right? McDonald's, right? They got the Big Mac sauce. Obviously, that's not applicable to healthcare, but we have something unique. We do things differently here. We have something proprietary, and I've shared that with my employees, and they should be able to profit off that when they leave here. So courts, they frame the interests, right? What's the employer actually trying to use this covenant to protect against? And then they say, is this narrowly tailored enough to protect the employer, but also not impose an undue hardship on the employee?
And I think folks should remember that the court will be looking at this with a strong propensity toward favoring competition. So a legitimate interest is not, I don't want Dr. Jason, 5 miles away from me competing because I think he's going to be quite good and it's going to erode my business. That's not a legitimate interest. Goodwill, protection of confidential information, those are legitimate business interests. Just to kind of rid yourself of what would otherwise be lawful competition isn't going to survive scrutiny.
Yeah, great point. And so as you can see, these three factors, is the restriction narrowly tailored? Does it present an undue hardship on the employee? And is it, quote, injurious to the public interest? These are all related, right? So the courts break the factors down, but they all play into each other. On the injurious to the public interest in healthcare, particularly, one factor that courts look at is the patient's ability to choose who gives them healthcare, right? So should this contractual covenant that the patient knows nothing about and didn't sign on for, should that prevent them from going to see Dr. Dave when Dr. Dave leaves Dr. Jason's practice? That's a tough conversation for Dr. Jason when he's trying to prevent patients from going where they want to go. So for years, up until 2016, Concord Orthopedics versus Forbes, which is a New Hampshire Supreme Court case, was the definitive case on non-competes in healthcare. Dave and I spent years, many years, just pulling out, dusting off Forbes and using that as the roadmap for whether, helping clients assess whether a non-compete was likely reasonable or unenforceable, etc. So, in that case, we're dealing with a couple-year non-compete physician who was leaving. It was a 25-mile, thou shalt not practice within 25 miles. And there were, really extensive arguments back and forth in the court about, is that enforceable? Is 2 years too much? Is 25 miles too great of a radius? Should the doctor be able to go after, treat new patients in that radius? Can they treat the practice's existing patients outside that radius? And there was a really robust and interesting discussion by the court. They ultimately upheld the non-compete and saying that the practice had a legitimate interest in prohibiting the former physician employee from competing for existing patients, right? So within that 25-mile radius, you can't go after our patients because we have goodwill. The patients attach you, they think of you as our doctor. So, you shouldn't be able to see our existing patients within this radius. And they upheld the 25-mile radius, and they upheld the 2-year, length of time, the temporal restriction. And there's some interesting stuff in that case, but just, that for so long, that was the only real authority that was related to healthcare that we had to rely upon. And we just set that as historical context because this all really shifted in 2016. So in 2016, the New Hampshire legislature passed a ban on non-competes for physicians. And we'll get, into this now, but that ban applied to all contracts that were signed after August 5th, 2016. So new contracts or contracts that renew after that date. So a lot of contracts have the initial term is 1 year and then it will renew. If the contract renewed after August 5th, 2016, that would serve to invalidate the non-compete. Importantly, our statute, the New Hampshire non-compete ban statute, is a mirror image of the Massachusetts physician non-compete ban, which has been in effect since the mid-1980s. So Massachusetts was way ahead of New Hampshire and a lot of the country on banning these. But I think, as you'll hear Dave and I say again and again, we've said it already several times, the devil's in the details. And so when you hear like non-competes are banned for physicians, really have to look at the language of the law. So here, if you look at it, and we've highlighted some terms here in red, the law defines non-compete as any contract or agreement which creates or establishes the terms of a partnership. So that could be an ownership relationship, right? Like between shareholders, between partners. So there's partnership. There's also employment. That's what we've been talking a lot about. Or any other form of professional relationship. So that could be like an independent contractor that comes to work for you. So it's any contract in those contexts with a physician that's licensed to practice in New Hampshire, which includes, and this is the key phrase, any restriction to the right of the physician to practice medicine in a geographic area for a period of time after termination of that relationship is void and unenforceable. So it's, right, there's a lot packed into this little paragraph. Any restriction, what does that mean? Geographic area, does this mean that only covenants that link it to geographic area are unenforceable? So as you'll see when we talk about Massachusetts, there's been some case law by the courts, because the ban has been in effect longer down there, that really bear out this term, at least in Massachusetts, as to what does any restriction mean.
Hey, Jay?
Yeah, Dave, go ahead.
I just want to point out also that notice that it relates to after the termination of employment. This does not apply to a restrictive covenant, for example, that would prevent or prohibit while the person is still employed at the practice.
Very important. That's very important. Because a lot of times in healthcare, folks are working at multiple different offices. Veterinarians do relief work all over the place. Specialty dentists, right? Oral surgeons, prosthodontists, they often will travel from office to office. And if they sign a contract with one office that has a non-compete in it, query how that's going to work, down the line. So it's really important to take a look at those and understand that. That same physician non-compete ban language has been utilized now by a bunch of other, or enacted in a law, and applicable to several other disciplines. So it's sort of the physicians got the non-compete ban, we want it too. So It's all down to the lobbyists, right? So send the lobbyists in to try to get us the same treatment. So in 2018, the New Hampshire legislature passed a non-compete ban using the same exact language, just substitute the term nurse for physician, that applies to contracts or renewals of contracts on or after June 25th, 2018. And nurse is defined to include registered nurse, licensed practical nurse, and APRN or nurse practitioner. Interestingly, last year, some nurse practitioners were coming forward and saying, although the statute includes us in the definition of nurse, employers are making arguments that APRNs are not actually covered by this nurse non-compete ban. So we want you, legislature, to enact a separate statute, separate section of the statute that states in plain language, crystal clear, non-competes are banned, post-termination non-competes are banned for APRNs. So the New Hampshire legislature passed that ban, same language, effective August 23rd, 2025. And now this next one is hot off the presses. So literally as we were preparing to give this webinar in May, Governor Ayotte signed a non-compete ban, same type of language, again, substitute physician associate, same thing, physician assistant, they just renamed it recently, PA, same ban that will apply to contracts that new contracts or renewals of contracts after July 7th, 2026. So this is not yet taken effect. It will take effect in a couple of months. And this is really important, and I think this is tied to the fact that until last year, PAs were not able, unlike nurse practitioners, to independently practice in New Hampshire. Now, under this new physician associate model, if you can show that you've had 8,000 hours of independent practice post-grad, you then will be able to practice independently. So the argument was out there from the PA Association lobby, like, hey, if we're going to be independent now, why are we not treated like APRNs and physicians that also can have these non-competes banned? And then finally, in terms of the list of statutory bans, podiatrists, gotta love the podiatrists, strong lobby. They have the same ban, same thing, effective July 25th, 2018. As Dave mentioned already, for all of these, PAs, podiatrists, APRNs, physicians, these statutory bans do not prevent non-competes that apply during employment, and they also do not prevent non-competes in connection with the sale of business or practice. So while you can't impose it on an employee, if somebody's selling their business, you can subject them to a 3-year, 5-year, non-compete, because the idea, again, is you're paying somebody a significant amount of money in exchange for them to successfully transition the practice and the goodwill over to you. So really keep that in mind as you're thinking about in what circumstances can we impose these restrictive covenants. So what that means, though, is that other than for physician, nurses, PAs, podiatrists, reasonable non-competes can be imposed. That leaves dentists, who I deal with a ton, veterinarians, physical therapists, psychologists, optometrists, mental health workers, alcohol and drug counselors, naturopathic doctors, chiropractic, acupuncture. I see these and we use these on behalf of our clients, and I'm reviewing these on a weekly basis for folks in all these different licensure categories. But yeah,
go ahead.
Dave, go ahead.
I think you're about to hit it now.
But even if you are going to try to impose a non-compete on these folks, there are still some other constraints under New Hampshire law that are applicable. So that's our next slide. So RSA 275-70 says, in order for a non-compete to be enforceable, you have to give a copy of the non-compete in whatever document that is, right? We already talked about this: employment agreement, deferred comp agreement, employment handbook. You have to give a copy of that non-compete language to the prospective employee before they accept the offer of employment. And the rationale there should be obvious, right? We don't want somebody to accept an offer of employment, get really psyched about it, and then you say, oh, by the way, on the first day in the intro packet, here's your 2-year, 20-mile non-compete. You want employees to understand the terms and conditions of employment, and that is absolutely a material term and condition of employment. And then on a related note, a lot of times we get clients that say, you know, we didn't ever use restrictive covenants before, but we just got burned. And so now we want to roll this out for everybody. We're just going to make everybody sign one of these things for all of our existing employees. You know, sign this or you lose your job. And that almost never works or is enforceable unless you as the employer give the employee, the existing employee, something in return. Right? So in return for signing this and agreeing to this restriction, we're going to give you a promotion. We're going to give you a raise. We're going to give you some equity in the company. We're going to give you a retention payment. Something to show if you're ever called into court that they knew what they were doing, they accepted this, and they got something for it. So Dave, I'm not sure if that's where you were going.
It wasn't, but I wanted to just add that even though the non-compete ban may not apply to the categories that Jay just articulated, that doesn't mean that Forbes and the other common law cases don't apply. There's still, all of those principles still apply, right? There still has to be legitimate business interests. The restrictions still need to be narrowly tailored. There's a good faith requirement. The courts are still going to kind of strictly construe these agreements. So remember that just because you may be in a category where the statutory ban doesn't apply, and you may have satisfied RSA 275-70 in terms of the notice that's given, you still have to have an agreement that would otherwise adhere to the principles that are set forth in Forbes and some of the other cases from the New Hampshire Supreme Court.
No, it's a great point. And even if you do all of that, there's another requirement or prohibition, which is you can't impose non-competes on what the statute refers to as low-wage employees. And so that's anybody making $14.50 or less an hour. Now in healthcare, there's not a lot of folks that are in that category, but it's just something to keep in mind, especially if you're going to be putting something like that in your handbook, right? And it's going to apply to, you know, the hygienist or the front desk or, you know, that kind of thing. All right, so we've covered New Hampshire. I think you have a good flavor for the landscape here. Moving on, just in the interest of time, we're going to talk about Maine for a minute. Dave and I practice out of our Portsmouth, New Hampshire office, so we're right on the border. I'm licensed in Maine. We represent a number of healthcare clients up in Maine, and we often have clients who live in Portsmouth but want to jump across the bridge and work in Kittery or Elliott or, you know, Saco or Biddeford or whatever. So this is a big development in Maine. So until recently, Maine had a law, which we'll talk about, but it applied to physicians and it applied to veterinarians, but it didn't apply to all these other categories of healthcare practitioners. And in April, the governor of Maine and the legislature passed a new law that's going to ban post-termination of employment non-competes for all non-owner healthcare practitioners. So that's physician, nurses, dentists, veterinarians, all those categories you saw in the bullets a few minutes ago, therapists, mental health workers, anybody that's licensed to practice in Maine that's not an owner, you will not be able to impose a post-termination non-compete for those contracts that renew or new contracts after July 13th, 2026. So again, this is brand new, and I can tell you our Maine clients are paying a lot of attention to this because it's a very big change that's going to happen in Maine.
Notice this is another example of the devil in the detail. Notice the difference in the statutory language in the New Hampshire law, the Massachusetts law, any restriction. Here in Maine, those that prohibit. And that gets at two very different things, different restrictions.
Right.
Something that prohibits competition is one thing, and something that merely restricts is another thing.
Yes. And you'll see, because we have another slide coming up, sort of all the types of restrictive covenants that don't fall within this definition. But just important to note, the main DOL is going to be in charge of enforcing this. There are civil fines and other penalties available if you actually impose one of these illegal non-competes. So as I just said, this slide covers sort of what's still permissible in Maine after that statute takes effect in July. So we've talked about this a lot, non-competes that apply during the term of employment, non-competes that entered into in connection with the sale of the business, non-competes for owners. And there's no, and they say in the statute that hold an ownership interest. They don't define the threshold. So some states will say if you have at least a 25% interest or a majority interest. Here it's any ownership interest conceivably. So courts will probably have to figure out, somebody has a minority, very minority, a 5% interest. Is that enough? Arguably under the statute, yes. But then there's also, confidentiality agreements, trade secret protections, non-solicitation of employees, patients, referral sources. Again, when working with your counsel, you'll have to look at the law and craft your agreements in a way that comports with the statute. As I mentioned a minute ago, Maine has had a non-compete law, not one that outright banned post-termination non-competes for licensed healthcare practitioners, but it did apply to physicians and veterinarians. It also prohibits imposing non-competes. There's a wage threshold, so you can't impose on anybody earning wages at or below 400% of the federal poverty level. Just like the New Hampshire law, there's one here, but again, devil's in the details. You need to notify the prospective employee and provide a copy at least 3 business days before whatever document, whether it's the offer letter or employment contract, is going to be signed. And this is a huge one. The effective date of that non-compete cannot take effect until the later of 1 year. So for new employees, 1 year after the employee begins, their start date, or for existing employees, 6 months from the date the non-compete agreement was signed. So this is something a lot of businesses miss, and they just assume that it's enforceable from day one. I will tell you that the employees are often aware through trade associations or listservs or otherwise about this sort of this gap in the effective date issue. So that's sort of Maine in a nutshell. This change is coming. And so if you are a Maine-based healthcare business, definitely reach out to your counsel, your legal counsel, to evaluate what you have in place now, and see what you can do. If you want, to talk to them about how can we revise things or how can we prepare for this new regime. And as Dave will talk about a little later, sometimes you can achieve a lot of the same effects of a non-compete with carefully crafted non-solicits or other covenants. So, moving forward here into Massachusetts, as I mentioned, Massachusetts has had a physician non-compete ban in effect since the 80s. There's a mirror nursing ban that's been in effect for over 20 years. Language is the same as New Hampshire, any restriction, right? So same for physicians, same for nurses, same for psychologists and social workers. So as you can see, it seems sort of arbitrary, right? Why not the podiatrists in Massachusetts? Why not the PAs? It really just depends on who's gone before the legislature, who's made the case, and how the legislature, takes action. So for Massachusetts, these are the statutory ban categories. But however, that any restriction language, this is really important for New Hampshire-based folks because, as I mentioned, our any restriction language, our non-compete ban is identical to Massachusetts. So as far as I'm aware, there's been no New Hampshire Supreme Court case that has dealt with this phrase, any restriction. So New Hampshire courts, as we've seen in the Consumer Protection Act and some other areas where our laws mirror Massachusetts, will look to Massachusetts case law to say, how have the courts down there interpreted the identical statutory language? So there's a couple of cases here that we're going to talk about. The first is this Falmouth OBGYN versus Abisla from 1994. So there was a non-compete that basically said, hey, if you go work for a competitor, you're going to owe us, you're going to have to pay a penalty of $250,000. And the argument from the physician in that case is, this isn't, if you look at it, literally the statute, it says any restriction on the right of the physician to practice within a geographic area for a period of time. And they said this liquidated damages penalty in this competition provision says nothing about a geographic area. It just says if I work for a competitor, I have to pay $250,000. So because there's no geographic hook, this doesn't get stricken down by the statute. And the court says, hold on a second. Any restriction, we don't care about that geographic language, because there's certain things that could have way more of an impact than a 5-mile radius, right? Just saying you can't compete anywhere. You can't compete. We're not going to mention for how far, right? That certainly has an inhibitory effect, and a $250,000 liquidated damages penalty sure as heck has an inhibitory effect. And we really are going to look beyond the terms, that term of the statute to say, let's look at the public policy. Let's look at what any restriction means. So in that case, $250,000 liquidated damages penalty was deemed to be a restriction on the right to practice. Similarly, and this is a big one, and this is not a Massachusetts Supreme Judicial Court decision, so it doesn't necessarily have, full precedential effect, but it gives an indication of how courts in New Hampshire might look at things. There was a non-solicitation of patients provision. It doesn't say you can't solicit patients within a 25-mile radius of the practice. It just says you can't solicit patients. Now, read literally, that would mean if you move to Alaska and you're in Massachusetts and you're trying to get our patients to follow you to Alaska, and they do, right? Like, how does that bear out? And there's no geographic restriction. And again, the practitioner there said there doesn't say anything about geographic restriction. The law says it has to be a restriction that has a geographic scope. And the court says, and I quoted it here, were that position correct, it would mean that a restriction like this, which is facially worldwide, escapes the statute, while an agreement limiting itself to a town or a short geographic region would fail. This doesn't honor the spirit of the legislation, so any restriction means any restriction. And this is why it's driven Dave mad over the years. It's driven me mad over the years. It's like, why are the courts so focused? Why are certain courts so focused, and why is the legislature so focused with these little, arbitrary geographic restrictions? Dave, I know you want to say something about that.
No, I'm glad that the court was not constrained by that. Otherwise, you would have ended up with the absurd result, right? So the courts are always going to try to avoid an absurd result.
Yes, for sure. Importantly, Massachusetts, just like I talked about with Maine, there's this Massachusetts Non-Competition Agreement Act. So just like in Maine, even if you are not one of the types of practitioners that are subject to that statutory ban, there's also this other law that says, hey, if you want to impose a non-compete on anybody, it needs to be in writing. You need to advise the employee of their right to consult with legal counsel before signing. You have to give it to them at least 10 business days before employment, right? So in Maine, it was 3. In New Hampshire, it was before. In Mass, it's 10 business days. And then the maximum duration post-termination of employment is 12 months. So if you have a 2-year or things like that, you're limited to 12 months. And then the biggest one that I talk to employers most about is you have to, while they're, during the non-compete period, so the 1 year, you actually have to pay the employee what's called garden leave payments. And by statute, it's 50% of the employee's highest annualized base salary during the preceding 2 years, or some mutually agreed upon other number, some other consideration. Interestingly, when I talk to most Massachusetts healthcare employers about these non-competes, like, okay, we want to stop this person from working, we want to send send that letter out, cease and desist, they need to stop. And you say, okay, well, just remember, you need to be paying them these garden leave payments. And almost inevitably they go, I don't want to do that. I don't want to pay. They don't mean that much to me, right? I don't want to pay them for that. I don't want to have, they're not even working here anymore. It's like, all right, well, if you're not willing to pay them, then clearly you don't view them as an actual threat to the goodwill, right? And those legitimate business interests. So it's a way to size things up. And then there's also, you can't impose non-competes on non-exempt employees under the FLSA. So a lot, and we won't get, this isn't an FLSA presentation. We could be here for an hour just talking about exempt versus non-exempt. So I won't go down that rabbit hole, but just suffice to say, remember, there's this other law out there. So we're going to wrap up our neighbor states here, and then we'll talk about enforcement and tips for protecting your business. So Vermont has actually been a state that for years, there's been no activity and there's no statutory bans. And it's just been like a couple of old cases that have that general, yeah, it needs to be reasonable. But there's been no action by the legislature. It's kind of like how New Hampshire hasn't gone down the recreational cannabis route when all of our neighbor states have. Vermont just really wasn't on this until recently. So in 2025, the legislature, put forth a bill that would have banned all non-competes for those making less than $100,000 gross, except in the context of sale of business or shareholder partnership. That was referred to committee. So that hasn't been, enacted into law, but it was an indicator for us, the court, our legislature watchers, that, hey, Vermont's starting to pay attention on this. And now, currently pending before the Vermont legislature, is a ban on non-competes for physicians, nurse practitioners, and physician assistants, unless they own at least 25% of the business. So that's that hook, right? You have to own some. If you have an ownership interest, then that makes sense why we'd impose these, and they should be enforceable. But if you don't, you can't. So if this law passes, again, this does not have the status of law. It's just a bill, but it's moving through the House and the Senate in Vermont. If this passes, this will be effective March 1st, 2027. So if you're looking to work in Vermont, if you have operations in Vermont, keep your eye on this prospective legislative ban. And just, that the fact that the Vermont courts are on this and paying attention. So we've covered the landscape. I think you all have a better sense now, hopefully, of the nuance that comes into this, these agreements and this practice. I'm now going to turn it over to Dave to talk a little bit about enforcement. So you have the non-compete, or you have the document that has the non-compete. What do you do next if you want to protect your business, and how do you enforce these things when you think somebody's going to be violating you, they might violate it, or they are violating it?
Thank you, Jay. Am I in control here? Maybe next slide. So I think we've talked.
Yeah, I
Jay,
think we're beyond the definitions.
Past the definitions.
Yeah, right. So just think 2 more slides.
There we go. Yeah. Okay. So the first, typically when there appears to be a breach, or a practice is concerned that there's a breach, and they've gathered some information on their own and they've involved counsel, and we have a general understanding and belief that there's been or may have been some violation, the first thing we typically do is prepare what we call a cease and desist letter. It's typically the first step in the process, and oftentimes it's the only real step in the process. But in these letters that we send, usually to the former provider employee, but we usually copy the new employer practice. so that they're aware. But what we do is we identify the obligations that the provider has from the agreement or agreements. We establish whatever we know at that point about why we believe there's been some breach of that employee's obligation. We give them a whole bunch of scary language about their preservation obligations and their duty to make sure that they preserve all potential evidence, including evidence that's digital, electronically stored information. We let them know that we are investigating actively, that we're monitoring, and that litigation may commence, depending upon how that investigation ensues. And then we usually seek assurances that within a pretty tight timeline, that they understand their obligations, that they're going to adhere to their obligations, and that they're going to preserve all of the information that we've told them to preserve. And sometimes more is required than a cease and desist letter. Before I talk about that, sometimes we have to skip over it entirely because the breach is so profound, and we understand it to be so profound, and the risk of harm is so substantial right from the get-go, that we do not believe that a cease and desist letter is going to have any beneficial effect, and that if we don't commence litigation immediately, there's going to be some real significant damage. But those situations are unusual. More typically, we send out the cease and desist letter, and the practice is satisfied that the restrictions are going to be upheld going forward. And to the extent that there's been any damage, there's been some type of usually some type of an agreement that's put in place after the cease and desist letter. But sometimes, even after we've sent the cease and desist letter, the party is either not responsive or the breaches continue, in which case we need to commence litigation in the court action. Next slide, please. You can see here from the title that the litigation is typically against the employee and the new employer. Please understand that it is sometimes against the new employer as well, but sometimes it's not. Sometimes, at least initially, it's just against the employee because we need a good faith basis. We can't just run into court and file actions against parties without a good faith basis to do it. And so we need to establish first that there's a good faith basis to do it. And the types of claims that we usually bring, or at the very least, we lawyers are trying to determine whether there's a basis for them. First, breach of contract. Obviously, if there's an employment agreement and there's been some breach, we're going to be pursuing a claim of breach of contract. The next two, fiduciary duty and duty of loyalty, they kind of go together, and they deal with, on the fiduciary duty side, partners, officers, managing agents, typically higher level folks. But even lower level folks have duties of loyalty. But these two kind of claims typically relate to any misconduct that occurred while they were still employed. Did they download patient information? Were they acting in some self-dealing way rather than to the benefit of the employer while they were employed? Then we also look for misappropriation of trade secrets, which is a statutory claim, both New Hampshire and federally. Tortious interference with contract gets back to the point I made about the new employer. Has that new employer practice been involved in trying to get that employee to breach their agreement with us? And so if we establish that they knew about the obligation and that they've somehow benefited from the ongoing breach, then we'll typically bring them right in as a named defendant in the case. And that's one of the benefits of sending that new employer a copy of the cease and desist letter, because usually we're going to append a copy of the employment agreement. So the new employer is not going to be able to contend later, hey, we didn't even know this person had these employment obligations. And same for the next theory of recovery, or claim aiding and abetting a breach of fiduciary duty. If the new employer is in there trying to encourage the employee before they leave to download patient information, to download any kind of confidential information from the practice, then there may be an aiding and abetting breach of fiduciary duty claim that we would bring. One thing I want to do quickly is to just distinguish between these types of violations, including some of these kind of pre-departure naughtiness on the part of the employee, and planning to compete. Not all plans to compete, not all activities while the person is employed that would plan to compete are necessarily unlawful. So it may be that an employee, while they're still employed, is researching potential real estate for a competitive practice that they plan to set up in the future, is taking some, maybe they have got a domain name established. Some of those preparatory steps are lawful. So not all competitive activities are unlawful. Okay, so it depends. Devil's in the detail. It depends on what they were doing. Okay, if they were downloading confidential information, if they were letting patients know about the fact that they were going to be leaving, that's in a different category altogether. Okay, next slide, please. All right. So when we talk about the enforcement process, assuming that we are in litigation now, or we're about to decide about litigation, first we want to know is, where are we going to be? What court are we going to be in? Sometimes the agreements will point to a particular state. All disputes arising from this agreement have to be in the state of Maine or have to be in the state of New Hampshire. Oftentimes they have those kind of provisions. And they often have, and the laws of the state of New Hampshire or Maine or Massachusetts are going to govern this agreement. So courts usually will uphold those, but the venue choice and the choice of law provisions that I just mentioned, they have to bear some reasonable relationship to the employment relationship that the parties had. So in other words, if an employer thinks that Nebraska law is really helpful to them and it's going to be super hard for the employee to go and litigate in Nebraska, but Nebraska has nothing at all to do with the relationship, that's not going to work. Okay, but if there's some reasonable basis for it, then that the court will typically uphold it. So you'd be in, let's say we're in New Hampshire court, then you've got to decide, okay, which of the New Hampshire state courts will we be in? These are not typically handled in federal courts. Sometimes they are, particularly if there's a federal trade secret statute action or claim. But typically, if we're just talking about a non-compete breach, then it's going to be in state court. But even within the state courts, we have choices about which court we're going to be in. And oftentimes, we'll want to be in what we call a business session here, where the judge handles lots and lots of these non-compete cases. And so the judge is very well versed on the law. And that can be really helpful. Sometimes it can be harmful. If the agreement isn't particularly sturdy and you've got it in front of a judge who's going to be looking right down in the bug dust at every little detail, then that may not be so helpful. We've got to marshal the evidence. We've got to preserve all the evidence on our own as well. It's not enough to just tell the migrating employee that they've got to preserve all evidence. We've got to do it too. And then we have to marshal all of that evidence, a lot of which is digital. And we've got to determine which witnesses are going to be helpful to us, which ones are going to be potentially harmful. We've got to decide, are we going to be able to get an injunction? And an injunction is essentially just a temporary order where we run into court early on and we ask the court to tell them to stop whatever they're doing, but now it has the force of a court order. It requires typically a preliminary hearing, special pleadings that are aimed at the injunction, but it gives the court an opportunity very early on to assess the party's likelihood of success, the strength of the agreement itself, of the evidence that they've brought before the court that there's been unlawful conduct. It allows the court early on to determine whether there's ongoing harm. or whether this is just something that can be handled with a damages claim and does not need the kind of extraordinary relief of a court going in and issuing court orders telling the practice in this case to stop doing X, Y, and Z.
Hey, Dave, we got about a minute left, just so you're,
Okay.
so
Okay,
maybe
yeah.
we'll just wrap up with some tips.
Yeah,
before
let's
we jump into
move over.
questions.
Okay, let's jump to the next slide. I will say quickly that on the prior slide, the damages, establishing damages can be very challenging because you've got to establish causation, that the reason why these patients are leaving is because of the solicitation, could be from other things. And so typically that requires expert witnesses who are very, very expensive. In all of the litigation process creates this collision, and a kind of collision between the HIPAA concerns and constraints, the confidential information that a practice is dealing with, and yet the basic understanding that when you go into court, that becomes public information. And so given that, the way we have to handle that is through protective orders from the court and motions to seal, and we're within court, but we're treating this information as confidential. And so it can get difficult, and it can get to be rather expensive, which gets to the costs and the fees part of the prior slide. When you're talking about expert witnesses, it's not unusual for expert witnesses to be many tens of thousands of dollars. They can exceed $100,000 in a case, just the expert witness. Legal fees alone are typically many tens of thousands and can exceed $100,000 without too much difficulty. So you've got to keep that in focus, right? The other thing I would add to the costs and the expense is the disruptive effect and the unpredictable nature of the outcomes. It's absolutely understandable when businesses come to us and when practices come to us, they want some certainty. Really, the best we can do is what a federal judge has said to me and to others, which is when everything goes right in litigation, you've got a 70 or an 80% chance of winning. That's when everything goes right. It doesn't get any better than that because there's just inherent unpredictability, and so you've got to be ready for that. The other thing, besides costs and effect and the unpredictability of it, is the disruptive effect. It has a hugely disruptive effect on your practice, on your other employees. And as much as we lawyers try to keep you as insulated from the ins and outs of the litigation, I find that folks have a hard time compartmentalizing it. And so they end up really being distracted by the litigation. Okay, let's quickly go to the next slide. So the tips for protecting your business. First, think carefully about what it is that you are intending to protect, and protect only that. And what Jay started with is and what is consistent with Forbes and the other New Hampshire cases is, if you want to protect your goodwill and you want to protect your confidential information, you can do that with restrictive covenants. Okay, you can do that with carefully crafted restricted agreements that are aimed narrowly at protecting those legitimate interests. You want to determine what laws apply. I think it's apparent that, first of all, we don't know necessarily which state law is going to apply, but even within a state, there are different laws that are going to apply to different categories. So it's imperative that you understand which state law may apply. It's important that you update agreements because for sure the law changes and it evolves. And so it's a very good practice to have your counsel periodically review your agreements. Even if you've done all that, you want to make sure that when you implement these agreements, that folks have been given proper notice and an opportunity to review them, and that there's an overall fairness to the employee. And if you think about that as a guiding principle, that the way you've navigated this is in a fundamentally fair way, that's going to resonate with the court almost every time. Next slide, please. Remember that not all your employees are the same. This is not one size fits all, even though it seems more efficient to do it that way. Somebody that sits at the reception desk is not the same as a hygienist, who's not the same as a partner dentist. And so the agreements have to reflect those differences. Because the devil is in the detail in so many places in these areas, in all of this restrictive covenant area, it's very important to involve your legal counsel early. Early assessment and guidance from your counsel is relatively inexpensive and immensely valuable later on. And oftentimes, settlement is the best outcome. It eliminates risk, right? So it's no more of that 70 or 80% chance. You can be 100% sure that the risk is eliminated. And you can substantially reduce and extinguish further costs, expert and lawyer costs. And oftentimes you can get the most of what it is that you wanted, the important stuff that you wanted. You may not get everything, but you'll get a lot through settlement. It's important, obviously, that a cease and desist letter go out, that the agreement is sturdy, and sometimes there's some preliminary litigation. All of that can lead to a very favorable settlement. But if there have been stumbles along the way, then it makes settlement much more difficult. It is also imperative that counsel be involved in crafting and drafting the settlement agreements. Sometimes I see parties that try to do it themselves, and the details have just not been adequately handled. So it's important that if there is going to be some agreement, that counsel is brought in at the very least in the drafting stage of it. Oftentimes I hear from employers that it's vitally important that they send messages to other employees through litigation. And my comment on that is that there's sometimes value in that, but it's unusual. And it's usually an overblown concern. And oftentimes whatever message was intended is not the message that was received. The best way to retain good employees is to very clearly articulate what the expectations and obligations are, and then to treat the employees fairly. Thank you.
Yeah, thanks so much, everybody, for attending. I've been answering some great questions in the chat, the Q&A session as Dave was talking. So we hope that everybody has had their questions answered. We apologize for going a few minutes over. This is an important topic, and there's a lot to talk about given all the legal developments. Feel free to reach out to Dave or me at any point if you have questions about things. Our contact information is at the end of the slides, and you can look us up on the web, etc. And we're happy to answer any questions now, Mike, if there's anything else that you have. But sincerely appreciate all of your time today, and hope this helps guide you in your work. And we so appreciate what you all do as healthcare providers. So thanks for your valuable service.
Yes, just want to thank Dave and Jason for providing a great framework for a very complex subject. And thanks to our sponsor, Sheehan Finney. Just a reminder that a recording of this webinar will be sent to your email address. So please look for that. And thank you so much for spending time with us today.